Welcome to this lecture sponsored by the Institute of World Politics. For those of you who are new, IWP is the Independent Graduate School of National Security, Intelligence, and International Affairs. We offer a doctoral program, 7 master's degree programs, including 2 online MAs and 18 certificates of graduate study. If you are interested in learning more about us, please visit us online at iwp.edu. We'd like to thank all of our supporters who make our IWP events program possible. To support the work of IWP, please visit iwp.edu/donate. Today we are here to listen to Dr. Marcin Romanowski. Mr. Romanowski is a Polish politician and a lawyer. His career in public service saw him serve as a Undersecretary of State in 2023, advancing to Secretary of State in the Ministry of Justice later that year. After a shift in the Polish political landscape, Romanowski faced political persecution under the Tusk regime, leading him to become the first political refugee from Poland since 1989. He was granted asylum by Hungary. Dr. Romanowski, the floor is yours.
The first lecture focused on discussing the initial steps toward transforming Poland into a lawless state under Tusk's government. This step was the unlawful, forceful takeover of public media buildings, followed by purges among journalists and the transformation of the media outlets into government propaganda tools. The second move by the liberal December 13th coalition was the illegal, forceful takeover of the National Public Prosecutor's Office, followed by a systematic takeover of regional and local prosecution offices throughout the country. This action aimed to subjugate a key institution of justice, responsible for prosecuting crimes, on the one hand ensuring impunity for their supporters, and on the other turning the prosecution into a tool for politically persecuting the opposition. The structure of the Polish prosecution service is hierarchical. At its head is the Prosecutor General, who is also the Minister of Justice, a member of the Council of Ministers, and therefore a political figure. However, the Prosecutor General's power are limited to general oversight and ensuring the government's influence on expected directions in criminal policy and the rule of law. Since the reform of 2022, the Prosecutor General no longer has the direct authority to influence the day-to-day operations of the prosecution, interfere with individual investigations, or directly manage personnel policy. These responsibilities are handled by the Prosecutor General's first deputy, namely the National Public Prosecutor. According to Article 13 of the Law of the Prosecution, the Prosecutor General directs the activities of the prosecution service either personally or through the National Public Prosecutor and other deputies issuing binding orders, directives and instructions, and representing the prosecution at a strategic level in external relations. Under Article 13, Section 3A and Article 18 of the Law of the Prosecution, the National Public Prosecutor, as the first deputy of the Prosecutor General, oversees and coordinates the activities of regional, district, and local prosecution offices. The national public prosecutor also exercises appellate supervision over preparatory proceedings, issues service orders within the competencies, and acts as the superior prosecutor over all the prosecutors, which includes oversight of specific cases. Significantly, the national public prosecutor, independent of the political prosecutor general, decides on the appointment and dismissal of regional, district, and local prosecutors, as well as the heads of organizational units. The national public prosecutor is appointed by the Prime Minister upon the recommendation of the Minister of Justice after consulting the President of Poland. Dismissal follows the same procedure, requiring the Prime Minister's action based on the Minister of Justice motion with the consent of the President. This is Article 14. These procedural provisions grant the national public prosecutor a relatively strong constitutional position. They also ensure a degree of independence from the pressures of the parliamentary majority, as the appointment powers for the national public prosecutor are shared among the Prime Minister and Minister of Justice, so member of the Council of Ministers, and the President, who is elected in a separate direct election. During the liberal December 13 coalition's takeover of power in fall of 2023, the national public prosecutor appointed under the above-mentioned regulations was Prosecutor Dariusz Barski, who had previously served as an advisor of Justice Minister and Prosecutor General Zbigniew Ziobro from the Conservative government. As discussed in the first lecture, a week after Tusk's government took power on December 20, 2023, the process of unlawfully and forcefully seizing control of public media began. Independent regional and district prosecutors in Warsaw launched investigations based on reports of abuse of power by Minister of Culture Bartłomiej Sienkiewicz and other officials. So according to Article 231 of the Polish Penal Code. As well as assault against opposition MPs and journalists. During the investigation, it was established that a notarial deed documenting the general shareholders meeting of companies managing public media had been falsified. The prosecution also intervened in registry court proceedings, effectively blocking the Minister of Culture's attempts to register new illegal management boards in public media companies. Faced with the effectiveness of the independent prosecution service, Tusk hastily moved to the control of the prosecution system. Tusk realized that the actions of the investigators would not only block the unlawful takeover of public media and lead to the prosecution of those responsible, including at least the Minister of Culture, but would also obstruct or significantly hinder the implementation of further unlawful actions by his administration. These unlawful methods of governance had become the hallmark of Tusk's government. Tusk's administration was effectively forced into illegal actions due to the lack of the 3/5 parliamentary majority required to override the president's probable vetoes of laws aimed at reversing the reforms introduced during 8 years of conservative rule. On January 12, 2024, Justice Minister Prosecutor General Adam Bodnar, during a meeting with National Public Prosecutor Adam Barski, handed him a document stating that his reinstatement to active service on February 2022 by former Prosecutor General Zbigniew Ziobro had been carried out in violation of applicable regulations and had no legal effects. As a result, Adam Bodnar declared that as of January 12, 2024, Dariusz Barski was officially considered retired, rendering him unable to perform the functions of the National Public Prosecutor. It's worth noting that Justice Minister Prosecutor General Adam Bodnar is a well-known Polish lawyer and human rights specialist who gained prominence as the ombudsman from 2015 to 2021. During his tenure, he became known as a proponent of woke ideology and its various applications within the legal system. He was and is still recognized for his actions promoting privileges for LGBTQ plus individuals and for his attacks on those people with conservative or Christian views. His ties to organizations associated with George Soros, such as the Open Society Foundation and many Polish NGOs collaborated with Soros, were significant. In the 2023 elections, he was elected as a senator with the support of the Civic Platform. And Prosecutor Dariusz Barski, a distinguished figure in the Polish justice system, had served as a Deputy Prosecutor General and National Public Prosecutor from 2007 to 2010. Following the 2010 reform, which took place under Tusk's first government, 2007-2015, the reform which resulted in the abolition of the National Prosecutor's Office, Barski was retired, and this was a part of the reorganization of the prosecution service. On February 16, 2022, he was reinstated to active service by Zbigniew Ziobro based on Article 47 of the Act introducing the law of the prosecution of January 2016. Under this provision, so Article 47, a retired prosecutor who retired during this reform 2010, so this retired prosecutor could, upon request, return to active service in their last held position or an equivalent position, provided they had not retired for health reasons, but because of the previous reform. The prosecutor general was empowered to make that decision, and at the same time, a prosecutor could choose to return to retirement from active service at any time. So go back to the retirement. Minister Adam Bodnar commissioned 3 legal opinions by Professor Anna Rakowska from the University of Łódź, by Professor Sławomir Patyra from Maria Curie Skłodowska University in Lublin, and Professor Grzegorz Kuc from the Jagiellonian University in Kraków. According to these opinions, the reinstatement of Prosecutor Dariusz Barski was deemed legally ineffective. The experts argued that the provisions of Article 47 of the Act introducing the law of the prosecution had an incidental character, meaning they were allegedly introduced to address a temporary issue resulting from the abolition of the National Public Prosecutor's Office and Appellate Prosecutor's Offices in 2010. According to these opinions, the 2016 law reinstating the National Public Prosecutor's Office allowed for the return to active service only within a clearly defined 2-month period after its enactment. It is from March 4th to May 4th, 2016. But how is this possible, given that the provision contained no time restrictions regarding its application or validity? The expert hired by the Prosecutor General Bodnar assumed a priori that the possibility of returning from retirement was transitional and episodic. They claimed that the absence of a clearly defined time frame from the for the provisions validity constituted a significant legislative oversight that should be corrected through general principles. Despite the lack of an explicit time limitation in the law, they argued that it should be interpreted in the systemic context and in light of the statute's purpose. And according to experts, the purpose of the law indicated that the provision Article 47 was primarily intended for the initial phase of implementing the new organizational model of the prosecution service in 2016. The experts emphasized that such transitional provisions are designed to address exceptional situations resulting from reform. They pointed to the 2-month period mentioned in other transitional provision, concluding that this was the general time frame envisioned by the legislator for implementing changes within the prosecution service. They also argued that since the procedure outlined in Article 47 was an exceptional method for appointing prosecutors, the principle of exceptiones non sunt extendende, exceptions should not be interpreted broadly, should apply. Having classified the provision as intertemporal, they concluded that the presumption of the application of new law should prevail. Additionally, the experts noted that while the law allowed prosecutors to return from active service to retirement at any time, no such phrase was included into the provision governing the return from retirement to active service. So the opposite direction. From this, they interread that the return from retirement could not occur at any time, but only within a limited time frame. So according to a contrario principle. Interestingly, the letter from the Prosecutor General delivered to Dariusz Barski on January 12, 2024 was meant to effectively end his tenure as National Public Prosecutor on that very day. A position he had held since March 2022. This interpretation is particularly surprising as Bodnar's reasoning suggests that Barski had not been a prosecutor for previous 13 years. According to Bodnar, decisions made by Barski during his tenure were deemed valid only to the extent that they were authorized by the Prosecutor General, while his independent decisions were subjected to a thorough review to determine their legality. This approach was, to say the least, without precedent. That is even less surprising given these circumstances that earlier in the same day, Dariusz Barski, acting as the National Public Prosecutor, promoted on the of Bodnar's one of the Bodnar's trusted prosecutor to the National Public Prosecutor's office, realizing the wish of Prosecutor General Bodnar. By evening, this individual, but by evening of the same day, of course, this individual had taken Barski's place in the role. Thus, Bodnar required the validity of Dariusz Barski's decision from the morning, despite questioning his legal authority himself. The interpretation presented by the Minister of Justice sparked significant controversy. I point this out because the method of illegal action through opinion has become a constant method of governance and was used against me as well a few months later. In that instance, entirely unreliable opinions commissioned to support a predetermined thesis were used in an attempt to justify my illegal arrest. In the case of the three opinions under discussion, we observe elaborate argumentative hyperbole, but this have one fundamental and insurmountable flaw. They entirely disregard the fundamental issue, namely the clear and plain wording of the law. In effect, they amounted to judicial lawmaking, while interpretative traditions allow such deviations in very exceptional cases. In this instance, there was no justification other than the political objective of taking control of the prosecution service. Such a motive cannot, of course, serve as a valid reason to disregard the plain meaning of the law. The quality of the reasoning in these three opinions commissioned by the Prosecutor General clearly indicates that their sole aim was to validate a predetermined conclusion which constitutes a blatant breach of professional integrity. This is no doubt that the provision in question remains in force, and it has not been repealed in any way. Regarding its application, since the law did not set a deadline limiting the possibility for a prosecutor to apply for return from retirement to active service, it logically follows that such return is possible at any time. If the law does not specify a time frame, establishing one through interpretation would effectively grant the Prosecutor General, by implication, the authority to reject an application after an arbitrarily determined period. This would violate Article 7 of the Polish Constitution, which prohibits the presumption of competences for public authorities. Additionally, the interpretation proposed by the Prosecutor General undermines other fundamental constitutional values and principles of democratic state governed by the rule of law, including the reliability and efficiency of public institutions, public trust, legislative rationality, and the clearly and meaning and certainty of legal provisions. it's implausible to consider that the provision are transitional. Rather, it should be understood, at least in my opinion, as substantive. Even if it were transitional, this alone would not imply a time limitation on its validity. But the provision remains effective and applicable as long as there are prosecutors who retired before the law's enactment and who might theoretically request a return to active service. There is no intertemporal element in the provision's construction itself. The factual transitive or temporary situations it governs will simply cease to exist once there are no longer any prosecutors in such circumstances. At most, the institution of substantive provision in the introductory legislation rather than in the law on the prosecution itself could be considered a technical legislative error, a common occurrence that should not have happened under the rules of legislative drafting. However, this type of technical inconsistency, which is frequently encountered, does not in any way affect the nature or scope of the application of the provision. The wording of which is, as was said, clear and plain. Even if there were any interpretative doubts, and there are none in this case, they would still have to be resolved in favor of the prosecutors in accordance with the principle of respecting acquired rights. Well, on the same day, January 12, 2024, Prime Minister Donald Tusk appointed Prosecutor Jacek Bilewicz as acting first Deputy Prosecutor General and National Public Prosecutor without consulting the President of Poland as required by law. The concept of an acting national public prosecutor is not recognized under Polish law. The only legal way to assign someone the responsibilities of the national public prosecutor, assuming the position was vacant, which it was not, would have been to appoint a new public prosecutor with the involvement of the President of Poland. A few days later, using the method of fait accompli, Prosecutor General Adam Bodnar blocked Dariusz Barski's access to his office and the National Public Prosecutor's office buildings in general, thereby forcibly preventing him from performing his duties as National Public Prosecutor or Prosecutor of National Public Prosecutor's Office as well. 2 months later, Prime Minister Donald Tusk, acting on the recommendation of Prosecutor General Adam Bodnar, appointed the the next one prosecutor, Dariusz Korneluk, as regular national public prosecutor. But this appointment, once again, was made without the involvement of the President of Poland, whose opinion is explicitly required by law. The case was also the subject of a Constitutional Court ruling. Proceeding in the case were initiated following a constitutional complaint filed by Dariusz Barski on January 15, 2024, along with request for a provisional ruling. On February 5th, 2024, the court ordered the Prosecutor General Adam Bodnar and all public authorities to refrain from any actions that would prevent Dariusz Barski from exercising the rights, duties and powers vested in him as prosecutor of the National Public Prosecutor's Office in active service and from performing the role of National Public Prosecutor. Specifically, the court instructed the suspension of the execution of the Prosecutor General's letter dated January 12, 2024. Additionally, the court halted the enforcement of the Prime Minister's decision, also dated January 12, 2024, appointing Prosecutor Jacek Bilewicz as an acting National Public Prosecutor and prohibited any actions by individuals appointed to this position without a legal basis. The ruling was intended to ensure that Dariusz Barski could continue to perform his duties without interference until the court issued a final decision. The government, however, refused to recognize the ruling, thereby committing another breach of the law. The decision to unlawfully deprive Dariusz Barski of his ability to serve as National Public Prosecutor was met with consistent opposition from three deputies of the Prosecutor General, Robert Hernand, Michał Ostrowski and Krzysztof Sierak. During the first attempt to seize the National Public Prosecutor's Office, Robert Hernand recorded a conversation with Adam Bodnar, informing him of the recording. During this recorded discussion, Hernand expressed categorical opposition to the unlawful actions. Notably, Hernand has served as a deputy to the Prosecutor General for many years, having been appointed to the position during Tusk's previous government, so prior to 2015. And I must admit that without his recording, the public would have had only a limited understanding of the lawlessness taking place in the prosecution under Bodnar. Consequently, the Prosecutor General initiated proceedings against Hernand, and in November 2024, Robert Hernand was charged with disciplinary misconduct for allegedly violating the dignity of his office by recording this conversation. These illegal changes in the leadership of the National Public Prosecutor's Office were followed by similar changes in the leadership of subordinate regional district and local prosecution units. The dismissal of incumbent leaders and the appointment of new ones in these territorial units were, however, fundamentally flawed from a legal standpoint. As previously noted, such changes can only be made by the National Public Prosecutor. However, the legally appointed prosecutor, Dariusz Barski, had been unlawfully and forcibly removed from his position, which was subsequently occupied by an illegitimate appointee. The illegal leadership of the National Public Prosecutor's Office also began the immediate dismissal of prosecutors from delegations and the implementation of so-called punitive transfers of inconvenient prosecutors to other territorial units, or demotions by 2 levels. A notable example is Professor Przemysław Ostojski, an internationally recognized specialist in administrative law and a prosecutor at the National Public Prosecutor's Office. He handled administrative court cases representing the Prosecutor General, Zbigniew Ziobro. Professor Ostojski was reassigned to the lowest level unit, which deals with straightforward criminal cases. Not coincidentally, Professor Ostojski's primary area of work during the conservative government had been protecting Polish legal order against strategic litigation from LGBT organizations, which sought to circumvent the law by using liberal administrative judges to obtain entries in Polish civil register, recognizing same-sex couples as parents. These efforts often relied on cross-border situations when one spouse with Polish citizenship had entered into a same-sex union abroad and acquired a child. During the tenure of the Law and Justice government, the Prosecutor General Zbigniew Ziobro effectively blocked such attempts to introduce same-sex parenthood into the Polish legal system through the back door. Polish Ombudsman Professor Marcin Wiącek expressed concerns regarding these punitive delegations. he pointed out that the sudden removal of a prosecutor from a delegation could violate their rights to respect for private and family life, stated in Article 47 of the Polish Constitution or Article 8 of the European Convention on Human Rights. But Poland is, as it's well known, a member of the Council of Europe, whose task is, among other things, to ensure the preservation of the rule of law standards in its member states. As a representative in the Parliamentary Assembly of the Council of Europe, PiS, I submitted a draft resolution titled Breaches of the Rule of Law in Poland as regards the prosecution service. It was during a PiS session, winter session on January 24, 2024. The draft resolution emphasized the rule of law as a cornerstone of democracy and raised concerns about actions taken by Poland's Minister of Justice and Prosecutor General Adam Bodnar. It detailed alleged violations, including the annulment of the reinstatement of former public prosecutor, national public prosecutor Dariusz Barski, bypassing the president's rule in dismissal proceedings and unlawfully appointing Jacek Bilewicz to a non-existent position as acting public prosecutor. These actions were criticized by all regional prosecutors as illegal attempts to undermine the rule of law. The draft resolution argued that such violation threatened democratic standards, eroded trust in the prosecution system, and called for an investigation into the matter, urging international solidarity to protect European values. Needless to say, I think that the draft resolution did not proceed to further consideration. On September 27, 2024, a three-judge panel of the Supreme Court's criminal chamber reviewed a legal question submitted by a lower court regarding the status of national public prosecutor Dariusz Barski. The Supreme Court resolved the legal issue concerning the validity of the provisions that allowed Dariusz Barski to return to active service from retirement in 2016. The court confirmed that Barski's reinstatement and appointment were legally valid and binding. Decisions made under these provisions, including Barski's appointment and subsequent actions, were deemed effective and lawful. As a consequence of this ruling, it was reaffirmed that Dariusz Barski continues to serve as the national public prosecutor, not Jacek Bilewicz, who served as an acting national public prosecutor from January to March 2024, nor Dariusz Korneluk, appointed to the position by Prime Minister Tusk in March 2024. Government representatives, including Prosecutor General and Minister of Justice Adam Bodnar, stated that they would not recognize the ruling, arguing that the judges who issued it were appointed to the Supreme Court by the National Council of Judiciary after 2018. So that is after the reform of this institution by the conservative majority at that time. This position of Tusk government violates Polish law. Furthermore, it finds no justification even in the case law of the Court of Justice of the European Union, which acting ultra vires, so outside the competences, so it illegal, issued a ruling concerning Poland's National Council of the Judiciary. These rulings, however, are improperly used by Polish authorities to justify unlawful actions. This is a much broader issue and is a subject for a separate lecture, of course. For now, but it's worth noting that the criminal chamber of the Supreme Court has never been questioned, and each of the three judges on the panel has 20, 30 years of experience, extensive appellate court backgrounds, academic credentials, and recognition as leading figures in criminal law doctrine. In November 2024, the case was also addressed by the Constitutional Court. During these proceedings, the Prosecutor General Adam Bodnar reiterated his earlier argumentation that Article 47 of the introductory provisions of the law on the prosecution has a transitional character. In contrast, Dariusz Barski argued that his dismissal as a national public prosecutor in January 2024 was unconstitutional, violating his right to access public service. He emphasized that Article 47, Section 1 and 2 of the law did not contain any time limitations, thus allowing retired prosecutors to return to their previous or equivalent positions, regardless of the time elapsed since the law's enactment. In its November 22 judgment, in the year 2024, the Constitutional Court ruled that the interpretation of Article 47, which would limit its applicability to a 2-month period, was inconsistent with the constitutional guarantee of equal access to public service, according to Article 60 of the Polish Constitution, and the principle of proportionality, according to Article 31, Section 3 of the Polish Constitution. The latter allows the restrictions on rights and freedoms only when necessary, strictly proportionate and serving the protection of democratic state values. The ruling of the Constitutional Court, like all its rulings since April 2024, has not been published in the official journal and is not recognized by government representatives. Interestingly, on November 27, 2024, the Supreme Court reviewed additional legal questions concerning the legality of appointing Jacek Bilewicz and Dariusz Korneluk to a position in the National Public Prosecutor's Office in place of Dariusz Barski. The case was heard by a three-judge panel, all of whom had been appointed to the Supreme Court before 2018, so before the reform of the conservative majority. What is interesting that two of the three judges on the panel were well known to be openly and actively sympathetic to Donald Tusk's government. Nevertheless, the panel declined to issue a ruling, arguing that the legal question submitted by the Warsaw Court of Appeals did not meet formal requirements. Specifically, it was stated that the question were individual in nature rather than fundamental, falling outside of the Supreme Court's competence. This refusal to issue a ruling left in place the earlier Supreme Court decision previously discussed from September 27, the same year, which had declared the removal of Dariusz Barski from the position of National Public Prosecutor legally ineffective. The new decision prompted worried reactions within legal and political circles. Notably, the panel's decision to avoid issuing a judgment favorable to the government, despite the majority of the panel being government-aligned judges, is interpreted by commentators as an attempt to avoid the negative consequences of endorsing the clearly unlawful dismissal of Dariusz Barski. This is seen as one of many examples where officials, judges, and prosecutors at the end of the year 2024 are no longer uncritically implementing government expectations. This phenomenon is described as an erosion of the lawless state driven by reluctance to take responsibility for unlawful decisions in face of the anticipated collapse of the current regime. This intriguing syndrome, characteristic especially of the early and late stages of lawless state, has been named the risk effect by the esteemed German legal theorist Robert Alexy. It is based on what appears to be a truthful assumption that ordinary officials or civil servants within the apparatus of lawless state are usually neither complete scoundrels or heroes, nor heroes or saints. Typically, they avoid actively engaging in unlawful actions, yet at the same time, they are not willing to openly risk their careers, let alone their safety. To boldly oppose the criminals in power. Their primary goal is survival within the system. They had the misfortune to serve during the reign of lawlessness. However, during periods of crisis in a lawless state, their stance shaped by calculation of risk can contribute to the erosion of the regime. In the early stages of its formation, before the system solidifies, and if the decision makers are not sufficiently brutal, they have no enough. They have no power enough. This stance might even prevent the regime from fully emerging. The risk effect manifests as reduced involvement in unlawful actions and more moderate decisions that the most fervent proponents of the system would expect. Naturally, all of this is motivated by a fear of future accountability should the regime collapse or fail to take root. For the risk effect to operate effectively, there must be a strong conviction that those participating in unlawful actions will inevitably, almost automatically face just punishment once the regime falls. For Alexei, this is an argument from lawlessness that supports the greater utility of a non-positivist concept of law. However, it can also serve as a general argument for making clear and equivocal declaration to hold lawlessness accountable. Such an approach does not stem from a desire to revenge, but it's just a rational stance that accelerates the downfall of a lawless regime. This growing conviction has been reinforced by the government's incompetence. The unexpectedly strong social and institutional resistance against the unlawful actions and the disastrous economic policies that have triggered a rapid rise in public discontent. Another significant catalyst has undoubtedly been Donald Trump's rise to power and the reversal of Washington's previous trend of imposing liberal governance. The three deputies to the Prosecutor General consistently opposed the lawlessness occurring within the prosecution system. In December 2024, Adam Bodnar, continuing his reprisals against his deputies, decided to transfer Robert Hernand and Michael Ostrowski to remote branches of the National Public Prosecutor's Office. This decision effectively removed them from their roles as deputies to the Prosecutor General. In response, Hernand and Ostrowski filed appeals in court challenging the validity and legality of these transfers, arguing that they deprived them of the ability to fulfill their statutory duties. A significant objective of taking over the prosecution structures was to block investigations conducted into cases involving or against politicians associated with Donald Tusk. Several senior politicians from the current ruling Liberal coalition, including individuals closely tied to Tusk, such as Sławomir Nowak, Stanisław Gawłowski, Tomasz Grodzki, Roman Giertych, and Włodzimierz Karpiński, were under investigation for serious corruption allegations. Legal proceedings against them had been ongoing for several years. For example, Roman Giertych, a prominent politician in the ruling coalition, a member of parliament and a lawyer implicated in the Justice Fund case, was suspected by the prosecution of involvement to the embezzlement of over 90 million Polish zloty, equivalent to about $24 million from a publicly traded company. The proceedings against him were discontinued in January 2025. The investigation into Tomasz Grodzki, former Speaker of the Senate from the ruling Civic Platform Party, involves accusations of obstructing the identification of the criminal origins of the funds obtained through fraud. Additionally, Grodzki is alleged to have received financial benefits under the pretense of voluntary donations to the Transplantology Aid Foundation in Szczecin. These benefits are believed to exceed 1.5 million Polish zloty, so about $400,000 US. In February 2024, so directly after takeover of the prosecutor's office, the prosecution withdrew its motion to lift Senator Grodzki's immunity, halting proceedings against him, even though a trial already commenced involving serious charges against his associates. The next one is Stanisław Gawłowski, He faces accusation of accepting financial benefits totaling at least 700,000 Polish zloty, so about 200,000 US dollars, money laundering and plagiarism of his doctoral thesis. He has been charged with 7 offenses, including 4 related to corruption. Although the indictment was filed before the change of government and the trial is going, unusual events have taken place, such as key prosecution witnesses retracting their important testimonies. It is worth noting that the allegations against 2 of the aforementioned politicians were first uncovered by Szczecin-based journalist Tomasz Duklanowski. After Tusk's government assumed power, Duklanowski became one of the most persecuted journalists in Poland. The next example is Sławomir Nowak, a close collaborator to Prime Minister Donald Tusk. Nowak is accused of leading an international organized criminal group operating in Warsaw, Gdańsk, and Ukraine, involving a total of 17 criminal offenses. Authorities discovered 5 million Polish zlotys, so about $1.3 million in corrupt funds hidden in his house. The indictment was submitted to the court in 2023, and the trial remains ongoing. The last but not least example is Włodzimierz Karpiński, who faces allegations on rigging tenders and demanding financial benefits totaling 5 million zlotys, so 1.3 million US dollars. In October 2023, he assumed a vacated seat as a member of the European Parliament, which resulted in his release from detention and the granting of immunity. After the prosecution was unlawfully taken over, the motion to lift his immunity was withdrawn, leaving the whole case in limbo. Well, despite all of these serious allegations, examples of allegations, the ruling coalition shows no intention of addressing corruption cases involving high-ranking politicians from the civic platform. Instead, it focuses its efforts on using the prosecution service to conduct political persecution against opposition politicians from the Law and Justice Party. Adam Bodnar, together with Prime Minister Tusk, orchestrated the takeover of the National Prosecutor's Office for political reasons, and subsequently initiated large-scale investigations resembling political witch hunt. Some examples of such actions will be discussed in the next lecture.